I'd like to call the meeting of August 4th, 2021 at start at 7:10 p.m. And if you'll join me in the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. And before we start with roll call, maybe give a little time there, but it's with a heavy heart that I announce the passing of our member, Don Cook. And it's with a heavy heart because he was a good friend. He was a team member of ours here on this board, and he will be missed. He was a good friend of mine. I've known him for 20 some years. We did a lot together, and he when I wanted, I told him to apply for the board. He had no questions about it and came right on board. So I want to send our, I'm sure it comes from all of us, send our prayers to his wife, Chris, and to the family. And we will miss him.
Had he been sick?
No, not at all.
Oh.
It was so, pretty quick up north.
Wow, I'm saddened by that.
Yep. So we're short him being here, but I'm sure he'll be in all of our hearts forever.
Wow.
So let's start with roll call, and just remember to announce that you're attending remotely from what county, city, township, or village in Michigan, or if another state is applicable. So, Paul, if you can start with that.
Sure. Commissioner Barr. Commissioner Barr, you're muted.
Okay, done. Joanne Barr, attending remotely, the County of Macomb, City of Fraser.
Thank you. Commissioner Czarnecki.
Kathy Czarnecki, attending remotely from Macomb County, Fraser, Michigan.
Commissioner Farina. Commissioner Farina, you're also muted. You're still muted, Commissioner Farina.
I'm going to log back in on my computer. My computer went into a mandatory update and threw me off of the meeting, so I'm on my iPad right now. My name is Frank Farina. I'm attending from Macomb County, Fraser, Michigan.
Thank you. Commissioner Kyle, I believe, is absent.
Yes.
Commissioner Perry.
Yep, Kenneth Perry Jr., attending remotely from the County of Macomb, City of Fraser in Michigan 48026.
And Chair Warnick.
Randy Warnick, attending remotely from Macomb County, Fraser, Michigan.
Great.
Thanks, Paul. First, I'm going to read a notice of electronic public meeting. To protect the public health in accordance with the City of Fraser's local state of emergency due to the ongoing COVID-19 pandemic, the Fraser Planning Commission will meet electronically on August 4th, 2021, in accordance with the Open Meetings Act, using the Zoom platform for video conferencing and public access. This notice is required to ensure that those wishing to observe and/or participate in the meeting have the opportunity to do so. The public can participate via the Zoom application, internet access via the Zoom website, and/or via telephone using the Zoom telephone number and meeting ID. The public will be able to hear Planning Commission members and will be permitted to speak for up to 5 minutes during the public participation portions of the agenda. Please note that callers and viewers will automatically be muted and must remain muted until called upon to speak by the chair. Written comments will be accepted prior to the date and time, no later than 4:30 PM on the day of the meeting by the building department at zoning@micityofFraser.com, which is the method by which members of the public may contact members of the public body to provide input or ask questions on any business that will come before the public body at the meeting. Public hearing comments will be heard during any public hearing that is conducted during the meeting, and other comments will be heard or reviewed during public participation. In the event of a change in the status of local states of emergency, Planning Commission meeting may be changed from a remote meeting to a live in-person meeting to be held at Fraser City Hall, 33000 Garfield Road, Fraser, Michigan, 48026, on the same date and at the same time. The city will post notice of any change in method of conducting the meeting from a remote meeting to an in-person live meeting, and or any change in the meeting place for this meeting to the city's website at www.fraser.mi.us. Interested parties should periodically check for such changes or contact the city clerk's office at 586-293-3100. City of Fraser thanks all of you for your understanding and support as we all attempt to navigate these challenging times together. With that said, I will give, I'm trying to figure out.
Approval of agenda.
Yeah, approval of the agenda. Oh, okay, I'm sorry. So do we have anybody that wants to make a motion to approve the agenda?
I'll make the motion to
Oh.
approve the agenda as written.
Before anybody seconds that, I'd like to make a change. Paul reminded me on part 6B to move up number 4, SP 2107, up before number 3. So let's interchange both positions, SP 21-06. And if anybody has any problem with that, is there anything, anybody have any comments on that?
Mr. Chair,
Yes. go
I
ahead.
think Mr. Erbil, one of the enumerations of the site plans changed also.
Yes,
Oh.
I think the order is okay. It's just that the item 3 is really 2107, not 2106 as it was published, and item 4 is 2106.
Oh, so that's it. So basically keep all the other text where it's at
Correct. Yep.
and just switch that. Okay, I apologize.
Thank you.
So would you like to continue with that motion, Commissioner Perry?
Sure.
And I'll second that then.
Okay.
Okay, so roll call on that.
Sure. Commissioner Barr,
Yes, I agree.
Commissioner Starnecki,
Yes.
Commissioner Farina,
Yes.
Commissioner Perry,
Yes.
and Chair Warnick.
Yes. Okay, so start with Chairperson's opening remarks. Tonight's meeting will follow the agenda that was posted online. Before we begin, it's important to let everyone know that the Planning Commission is created by state law. The commission is comprised of 7 members, all of whom have volunteered to serve. Members are appointed by the mayor and confirmed by City Council. When roll call is conducted as we did previously this evening, the Open Meetings Act requires each member who is attending remotely to announce the following: attending remotely from county, township, city, village in Michigan. The role of the Planning Commission is to plan and promote the efficient, coordinated development of the city for the health, safety, and general welfare of its residents. We are not here to negotiate with applicants or allow everything an applicant is requesting. However, the Planning Commission does have the power to approve certain requests and recommend others, depending on the nature of the request and whether all the standards in the zoning ordinance have been met. Planning Commission may also impose conditions on a proposed project in order to ensure that those standards are met. Other individuals here with us today are representatives from the legal firm of O'Reilly Rancilio PC and representatives from McKenna and Associates. The procedure followed by the Planning Commission for public hearings first involves the city planner providing an overview of each case. After the overview is completed, the petitioner will be asked to provide additional information and answer any questions commission members may have. After the commission's questions, the public will be invited to speak. Each person will have one opportunity to speak, must only speak directly to that specific case, and must only address the commission, not the petitioner or anyone else in attendance. After the public has had an opportunity to speak, commission members may again ask questions of the petitioner, and then the commission will consider a motion. Now that we've gone over these guidelines, we'll begin with our agenda for this evening, starting with item number 5, approval of the minutes of last month, or the meeting of June. I don't have that date right in front of me, but
June 2nd.
June 2nd. So I'll accept motion to approve those as presented, or if anybody has any changes.
Mr. Chairman,
Yes.
I had one
Attorney
small correction that I passed on to Paul. It's on page 4, under item number C. The second line under discussion, the word "are" should be changed to the word "is," so it matches the subject tense or the subject of City of Fraser. Is permitted to meet virtually until the end of the year. That's the only change I found.
Okay. Any other changes from anybody else?
Nope.
Consider a motion to approve it with those changes.
I move to approve the minutes from June 2nd with the change that was noted.
Approval by Commissioner Farina. Do I have a motion to second that?
I support.
Support by Commissioner Zarnecki. All right, thanks. So now we can move on with our new business.
Chair Warnick, should we vote on that?
Oh, I'm sorry. Go ahead, we'll take roll call.
Commissioner Barr,
Yes.
Commissioner Zarnecki,
Yes.
Commissioner Farina,
Yes.
Commissioner Perry,
Yes.
and Chair Warnick.
Yes. That motion is approved. So we'll continue with our meeting with new business. Now, we have no public hearings. So we'll start with site plans and other reviews. And B1 is site plan 20-004, Wesley Berlin on behalf of Autozone Development LLC. Address to be determined on the west side of Utica Road, south of Meyer entrance. Request for site plan approval for approval extension. Is anybody present from that company?
Yes, I believe Wesley Berlin is.
Yes, hi
Yeah.
everyone. This is Wesley Berlin with Spartan Engineering.
Okay, Wesley, if you can give us you gave us your name, but give us your address too.
Yep, address is 2583 Pine Bluffs Court, Highland, Michigan 48357.
Okay, thanks. So, Paul, do you want to give us a background on this?
Yes, thank you. So last August, the commission approved 2 site plan applications, one for a new AutoZone retail location on Utica Road in the outlot of the Meyer. And the second one is a revised site plan for Meyer to accommodate the AutoZone development. The AutoZone site plan was to build a new retail location on that outlot. That approval was conditioned on some shared parking access and utility easements being presented to the city attorney for review and recorded. That there was a condition about adding a bike rack to the project, and lastly, it was conditioned on Meyer receiving a site plan approval for an amendment to their site plan to reduce the parking space count as a result of the outlet development to 1,079 spaces. So that was approved with conditions. The Meyer site plan amendment was approved with the condition that a reserved parking agreement be reached between the city and Meyer and recorded for the 70 space reduction that that was necessary beyond previous variances granted for the development. The applicants have been working with the city. There's a lot of procedure that preceded this one, and just some corporate policy and some city policy that meant that permits could not be issued until the property closed. The property could not be closed until the other, the easements and everything had been resolved, and also the applicants, the AutoZone's corporate policy that they don't close on property until permits are received. As you see in the letter that we provided to you, the applicants have fulfilled most of the conditions. The easements have been presented. The reserve parking agreement is not complete, but nearing so. And in summary, we believe that the applicants have been acting in good faith to move towards this, but because of all this, they've not been able to realize physical improvement on the site. The Fraser ordinance requires that physical improvement has commenced before 1 year. Otherwise, the site plan approval expires and the process needs to start over. So the applicants are requesting a 12-month extension on that site plan to account for the rest of the paperwork being finalized and to give a little bit of cushion considering the timing. It's now August. If construction doesn't commence before the season ends, then it may go into next year. But essentially, we believe that everyone's been acting in good faith, that there are good reasons that it hasn't started. So we think this is a reasonable request to grant.
Okay, should we combine that second half and vote on this as one? Because since it's the same extension, right?
I think you should take them separately because they're two different applicants. One of them is a Meyer case and one of them is an AutoZone case.
Oh, okay. That makes sense. All right, so we're on the AutoZone one then right now.
Right.
I have a question
Go ahead.
for our attorney, Clark.
Yes.
Do you think it should be held up this long to get this agreement on this parking? Does it take a year to get a parking agreement? Hello?
Well, there were a number of things. There, in the midst of this, the lawyer that was involved in it for AutoZone passed away, and so we lost some time with that. We lost some time with the COVID. The land division process took some time as well. We're almost there. The only real issue remaining is a discussion about what the consequences should be in the event that they don't do what they are supposed to do. Paul and I sought to get some input from the new city manager about that because she's in charge and she needed to familiarize herself some with it as well. So we're getting very, very close to having it finalized. But I don't think it was unreasonable under these circumstances.
Okay, so we don't have any legal issues with that then?
No, I think it's gonna work out shortly.
Okay.
Do we first? Let's go to the petitioner. Do you have any comments to add to Mr. Urbiel's presentation?
Yeah, thank you to Mr. Urbiel. I think that was an accurate description overall. AutoZone is currently tentatively scheduled to close on this on August 12th. That's subject to change, but that's their current timeline. And the intent is to get these easements executed and finalize the permits with the city as soon as we can and get under construction.
Okay. Any other comments or questions from the board?
If it's going to be soon, why do we need to extend it a whole year? Is that just convenience?
There's no reason that you have to do it for a year. I think that the thought process was that they're going to beat that time by a long time, but in case anything came up,
Okay.
Well, Clark, as the approval of a site plan extension, is it automatic since you're it's not a new site plan number or anything, but does the extent, is that a standard procedure to just, as it's extended, it gets another year since you're approving it? Since all approvals are conditional to 1 year, you can, can you actually,
I think you can, I could think you can extend it for a shorter period of time if you want to, but I think that since typically the site plans are in a 1-year cycle, I think that's where, how the request came about that way.
Okay,
that's. Commissioner Zarnecki, do you have something?
Oh, thank you, Mr. Chair. I was just asking if we do go forward with the approval, do we make the same conditions?
Yes.
Okay, thank you.
Okay.
I'm fine with extending it for a year. I think that would be customary.
Is there any other comments or questions? I do want to make all the petitioners aware of that we do not have a full board tonight, but we have a quorum. And if you feel like you want a full board, you have that right. So we're going to assume not if you don't say anything. So just remember that when you are presenting your case.
Mr. Chairman,
Yes, Mr. Andrews.
I just want to make one technical correction to that. Certainly people can make a request for to have it postponed, but the planning commission is never in a position to guarantee a full board. And in this instance, where there's now a vacancy on the board, I don't, it will depend on how soon the city council finds a qualified applicant to fill that position before we are in position to have a full board again. So I think it's okay to tell people that they can ask for a postponement since we only have 5 members and present, and there's only 6 members on the board at this point, but we can't guarantee that if they ask for a 1-month postponement, we can't guarantee that they're going to get a full board next month or even the month after that or any month, because we don't know what people's schedules are like and how the board composition will come about in terms of filling the vacancy.
I understand. Thanks for correcting me on that. So let's continue. Does anybody want to make a motion on that?
I make a motion to extend the site plan for SP 20-04 Wesley Berlin on behalf of Autozone Development LLC on the west side of Utica Road, south of Meyer entrance. Request for site plan approval extension of 1 year.
Do we have anybody support?
Excuse me, just a second.
Oh, sorry.
All of the conditions from the prior approval stay in place for this approval.
Okay, thanks for adding that. Anybody want to support that?
Mr. Chair, I can support. I would like the resolution to note that the applicant has acted in good faith to try to complete the site improvements.
Okay. Is that okay, Frank?
Sure.
Okay. So let's have a vote on that. Roll call.
Commissioner Barr,
Yes.
Commissioner Zarnecki,
Yes.
Commissioner Farina,
Yes.
Commissioner Perry,
Yes.
and Chair Warnick.
Yes. So that passes. So let's move on to the next one, number 2, site plan 20-005, Wesley Berlin on behalf of Meyer Incorporated, 35835 Utica Road, request for site plan approval extension. Mr. Urbiel, can we have?
Yes, so as I had mentioned, the amendment to the Meyer site plan was required as part of the AutoZone site plan, and what is remaining on the Meyer site plan is the resolution of that reserved parking agreement that Mr. Andrews and Commissioner Farina were speaking about just a few minutes ago. So the applicant is here on behalf of both entities and has been integral to completing those. So I think he can answer any more questions, but we have the same recommendation about this site plan extension.
Mr. Berlin, would you like to add anything to that?
No, thank you, but I definitely can answer any questions or add input if I need to. Thank you.
Okay. Any comments or questions from the board? Seeing no questions, I'll see if does anybody want to make a motion.
Anybody else?
Mr. Chair,
Good.
Mr. Chair, okay, I will,
Commissioner Zarnicki.
thank you. I will move to grant the request for site plan approval extension for site plan number 20-005, Wesley Berlin, on behalf of Meyer Incorporated, 35835 Utica Road, with the same condition as was previously approved for that site plan.
I'll support that. Let's take a roll call vote.
Commissioner Barr,
Yes.
Commissioner Zarnicki,
Yes,
Commissioner Farina,
Yes.
Commissioner Perry,
Yes.
Chair Warnick.
Yes. Okay. So that passes. So let's go. Thank you, Mr. Berlin. Now, do we usually stamp extensions like that? Do we need to give anything to the petitioner?
I don't think so.
We're okay then. So just this meeting and the extension gives him
Right.
that. Okay. Appreciate it. So let's go on to 6B3. So we changed that to SP 21-07. Kevin Tuchowski on behalf of Madi Basha, 33050 Utica Road, proposed site plan amendment. Mr. Tuchowski out there?
He is present, yes.
Yep, I'm here.
Okay, Kevin, can we get you to give us your full name and address?
Yep, Kevin Tuchowski. My address is P.O. Box 183655, Shelby Township, Michigan.
Okay, thanks. Can you give us background on that, Mr. Urbiel?
Yes. So this site is 3305 Utica Road. It's zoned community business district. The site has already been developed. The building was previously in use as a bar and a restaurant. It's been acquired by the Fraser Eye Care Center, which owns the two parcels immediately to the north. The Eye Care Center plans to convert this building into an administrative office for its staff to do the back of house functions and to free up space in the clinical building, which is currently operating. So the site plan application is to convert the use and to slightly modify the parking lot, removing 3 existing parking spaces for an outdoor area for the staff and add additional landscaping. The use is permitted, the office use is permitted in CBD. We basically, the removal of the parking spaces does not jeopardize the parking provision as required by the zoning ordinance. There are 51 spaces existing, 48 spaces proposed, and only 29 spaces required for that use in that building. The landscaping is compliant with the zoning ordinance as well. Our only suggestion, our only comment about this is that because this parcel shares access to Utica Road with the parcel to the north, also owned by the Eye Care Center, we suggest that there's a cross-access agreement between the two parcels recorded, and it's our understanding that the applicant's attorneys are working with Mr. Andrews, or at least have initiated the conversation with Mr. Andrews to do that. Otherwise, this proposal meets the zoning ordinance, and we have no further concerns.
Thank you, Mr. Urbiel. Mr. Tuchowski, you have anything to add to that?
Yeah, thank you, Mr. Rubio. I appreciate that. So just to further that statement, so obviously the clinic has purchased this parcel to the south. They're trying to, the intent is, as many of you know, I last year was in front of the council to remove the house on the north parcel to add additional parking. So with that, this building has been purchased for administrative use, of which will be submitted under a separate cover when the interior is developed. Um, uh, the intent of the physician and physicians is to create a campus-like, so they're trying to make the buildings all kind of blend together and create not only an enhancement on the outside, but a future development on the inside as well. So.
Okay, thanks. Are there any questions or comments from the board?
I have two.
Commissioner Farina?
How does this fit into the master plan? I'm sorry, I don't remember what district that was, Paul. Do you remember offhand what district?
CBD. Yeah, CBD.
It's CBD, so it's CBD is intended to encourage walkability, livability, and economic growth within the
Okay.
CBD with a downtown-like feel. Small office space, including medical offices, are identified in the master plan as an appropriate use.
Okay. And normally when somebody, if they want to put that into one campus, why don't we ask them to merge those two properties so we only have to bill one address or one? Isn't that normally what we do?
Yes, I think there was a desire to keep them as separate parcels, but that request could be made of them. I did have that conversation at least with Mr. Tchaikovsky. And so I think it's that would be the ideal situation. I think but it's possible to allow them to operate separately if the access is, if there are cross-access agreements. The parking is not necessary. The parking stands on its own for that permitted use. So I think as long as the proper agreements are in place so that it can function if that property was sold, then you can proceed. But if it's the commission's prerogative to require that they can be combined as well.
Well, what is your recommendation?
My
Mr.
recommendation is
Wyatt.
that there doesn't seem to be a compelling reason to require the combination if there's a cross-access agreement.
Okay. Thank you.
I concur with that, and in fact, we have had already exchanged comments about the cross-access agreement, and I sent them what my comments are, and they're working on making revisions in accordance with those comments.
Okay.
Any other comments or questions?
I have a question for Kathy. Kathy, do you want a bike rack on this thing?
Sure, I would love a bike rack. Yes.
Okay.
Yes. I have a question. How many of the employees like to play ping pong?
That was my question.
Yeah.
I think that's a great idea, but they must have an interest in it.
That I can't answer how many employees like the game of ping pong. This is obviously something that the ownership has indicated that they'd like to provide for staff. So I think I agree it is a good idea as well. Well, to be seen as to how many you'd play.
Is that a 4-season table out there somehow, or does that come in for the winter?
You know, it is a 4-season table, but the intent is to bring it in just like the other tables and chairs. It will be brought indoors.
Okay. Yeah,
Thank you,
it's
Mr. Farina, about the bike rack too. I appreciate your thoughts.
Kathy, I've been seeing more bike riders in Fraser lately than I ever did before.
That's because our bike racks are out there, Joanne.
Yeah, that's right.
Oh, yeah.
Anybody else have any comments or questions for Kevin? Well, Kevin, I think you're doing a great job here. Each time you improve the downtown with all these different things you're doing to their building and to this new building. So hearing no other comments. Well, is there anybody in the public that has any comments? I forgot to ask that last time. Seeing none and no other comments from the board or questions,
Nope.
I'd like to make a motion then to approve site plan 2107's site plan amendment, proposed site plan amendment for Kevin Tuchowski on behalf of Madi Basha for 33050 Utica Road. And with the approved site plan with the following condition, that the applicant provide a cross access agreement between the parcels at 33080 and 33050 Utica Road to the city attorney for review prior to executing and recording the document with the Macomb County Register of Deeds. And two, that the applicant obtains all other required city or other governmental reviews and approvals before proceeding.
Before Randy, and 3,
And
the bike rack.
3, yes, I'm sorry. And the addition of a bike rack, do we have a number that we put on that holds how many? A certain amount?
No,
Kathy, no
I don't
problem with
think we've
that?
ever put a number on that. No,
Yeah,
no.
I would say more than 2.
I don't think so.
So, and I think it'd be an addition anyway for a lot of people, whether they live near here or like to bike, if they're going to be employees there. I think having that as an option to all the employees that work in the city of Fraser is a good thing. And it'll help, I think, that area and promote physical fitness, Kevin.
Not a problem.
Any support for that?
I support.
Okay, so Chair recommends and support by Commissioner Farina. Roll call.
Commissioner Barr,
Yes.
Commissioner Sarnecki,
Yes,
Commissioner Farina,
Yes.
Commissioner Perry,
Yes.
and Chair Warnick.
Yes. So that motion passes. And let's continue on right away then to SP 2106, which is Kevin Tuchowski on behalf of Madi Basha, 33080 Utica Road, proposed site plan amendment. Do you want to give us background on that, Mr. Urbio?
Yes, so this is the existing clinical building that was part of the approved site plan that this body approved, I think in 2019, to expand its parking lot with the parcels to the north. The proposal here is to amend that site plan to remove the existing parking 6 spaces that exist in the front of the building and replace it with landscaping and a patio. These the spaces that are in question are served by an access drive that is not compliant with best practice or the city ordinance. I think also it's an awkward driveway that is narrower than it should be for two-way traffic. It's our understanding that the clinic frequently only allows employees to park there instead of the public because of issues with that. So I think in general, we see this as an improvement to the site. The Utica frontage gets a better appearance with landscaping instead of parking. And the amount of parking provided is still adequate in line with the previous approvals, less the 6 spaces. There are still 100 and, excuse me, the reduction is 113 to 107 parking spaces, which is still over the requirement of the previous approval. Our only comment here is identical to the 3305, which is that cross access agreement be added to the or be recorded between these two parcels to ensure that they both work if ownership changes.
Mr. Chachowski, would you like to add anything on that to that?
Yeah, the only comment I had is basically parallels Mr. Urbiel's. If you drive by this particular parcel at any given time during business hours, there's orange cones out there. On the demo plan that was submitted as part of this package, it indicates, as Mr. Urbiel did, the narrow approach that does not comply with two-way traffic. There's been some adverse situations there where the building has been hit, cars have been hit, and there's been some potential patron problems. So that just backs the reason why we're asking to remove the parking spots in the impervious area and replace it with landscape to not only enhance the building, but to enhance patient safety as well.
Thank you. Makes sense. I'd see that parking lot has finally come to completion after a long period of time. Mr. DeStefano working on it through some abnormal conditions of weather and that. So I was just glad to see him finally get that done. Really
Yeah,
looks
us too.
nice. Yep. Any comments or questions from the board?
Mr. Chair,
Commissioner Zarnecki.
I'm just going to ask the applicant if the patio is going to be used by the employees or the patrons or both.
It'll be both.
Thank you.
Yep.
Okay. Yeah, that waiting room's always got people in it, so that'd be nice to let them go outside too if they want to, if they're waiting.
Absolutely.
Good idea. Anybody else? Nobody else? Anybody in the public want to be heard? I'll bring it back to the board then. Anybody want to make a motion?
Okay, Mr. Chair.
Okay.
Go ahead,
Commissioner
Mr.
Zarnecki.
Farina. Go right ahead.
No, go ahead. I
Okay.
don't need to do them.
I move to grant approval for site plan number 21-06, Kevin Chukowski on behalf of Madi Basha, 33080 Utica Road, with the following conditions. 1, the applicant provide a cross-access easement between the parcels of 33080 and 33050 Utica Road to the city attorney for review prior to executing and recording the document with the Macomb County Register of Deeds. And 2, the applicant obtains all other required city or other governmental reviews and approvals.
No bike rack on this one?
No bike rack?
Can we add a bike rack on that location too? Number 3.
Certainly.
Thank you.
Mr.
Chachowski.
Chairman,
Clark, you're not coming through.
Mr. Chairman, are you frozen? Did Ms. Zarnecki make reference to that being a site plan or an amendment to a site plan? I didn't hear the amendment part, and this is an amendment to an already approved site plan, I think.
Thank you, Mr. Andrews. I will make sure that it's clarified as site plan 21-06 site plan amendment.
Thank you.
You're welcome.
Okay, we have that, and we have support by Mr. Farina.
Yep.
Okay. We'll go roll call on that.
Commissioner Barr,
Yes.
Commissioner Zarnecki,
Yes.
Commissioner Farina,
Yes.
Commissioner Perry,
Yes.
Commissioner Warnick.
Yes. That motion passes then. Mr. Chachowski, you guys are doing a great job there. We'll get you some stamp drawings on this one because it is a site plan approval. So even though it's an amendment, we'll still have to stamp these for you and get them at the City Hall offices for you.
Great. I thank you very much and thank the commission for not only reviewing this parcel, but obviously the parcel that was presented before this.
Hey, thank the doctors for doing a great job down there.
I've heard
I most
great things.
definitely will. Thank you.
Thanks. Okay, ready to continue on? Let's go to B5, site plan 21, or B4. No, B5. Why is my site plan different than what you're showing me?
Because there's an error in the PowerPoint. It's 2108.
It is 2108, okay. So this is site plan 21-08, Jim Butler on behalf of A&A Management, part of 33400 Utica Road, which is for a proposed site plan amendment. Is the petitioner present?
Yes, Jim Butler with PEA Group. Address is 2430 Rochester Court, Suite 100, Troy, Michigan, 48083.
Thanks. Welcome back, Jim.
Thank you.
Mr. Urbiel, you give us a background on this now.
Yes, so the the commission is probably very familiar with this proposal. This proposal is very similar to the one that was approved in June of this year. The main physical difference is that the applicant now proposes to use the footprint that was approved previously to, instead of have an outdoor patio, have an enclosed building over a 6,000, an approximately 6,000 foot building. So the elevations are different and that footprint is different. The rest physically about the site plan is identical. In the previous proposal and the previous approval, this space was accounted for as restaurant seating, and therefore the parking demand does not change by virtue of this particular change. But the elevations are different, and the proposal is slightly different, so they're asking for approval for this instead. And then secondly, the applicant is requesting that the commission remove the condition that all the parcels be combined before the outlot is divided from the main parcel. It's my understanding that that request is being made to facilitate some development flexibility in the future. That condition, as you know, has been part of this approval through the many iterations, and it was made to ensure that the parking, which is always been an issue in this discussion, that all of the parking that is available and under agreement is always available in the case of extreme events. If you recall, the modification to not develop the second outlet made this proposal be the parking that is provided as part of this proposal and as part of the agreements that are proposed or in process. For everyday use, the parking is adequate, but according to the engineer's review last time, extreme events would still require some additional mitigation. And so you approved the site plan with that extreme event plan intact last time due to that. Again, so this is, I guess, related to the question about whether or not the combination should be required. I think the important thing about that combination was that the parking was provided. And so I think that it's possible to approve this and grant that request, but only if agreements and easements are recorded between the north parking, the north parcels, the parcels that contain the north parking lot, and the main parcel, so that in effect the same parking provision is in place, as you all have been considering several times now. As I said, other than the physical other than the changing of the building from a building with a patio to just a building occupying the same footprint, the rest of the proposal is the same as it was before and meets the zoning ordinance requirements. We provided the same list of conditions that were previously approved because basically the facts are the same. And if you choose to do so, I think we modified the recommended condition for lot combination if those easements are included to ensure the parking is provided.
Thank you, Mr. Erbil. Mr. Butler, can you add to the planner's presentation?
Sure, there's a couple of things I just would like to point out. Actually, the building got larger by 54 square feet. So pursuant to the ordinance, based on parking, we were required to provide one more space. So previously we had 71 spaces required. There are 72 spaces that are required. There's plenty of parking for this, no problem. Regarding cross-access easements, it is the intent to provide what's known as a reciprocal easement agreement, which will cover the parking, utilities, and access for all the parcels within the development.
Mr. Chairman,
Yes, Mr. Andrews.
I'm glad to hear that. I would also like to add that it was the intent of the commission, and certainly my intent as well, that the documents that related to allowing the shared parking, that those would, the prior motion indicated that those had to be reviewed and approved by our office and also recorded. And the documents that have been provided to us thus far do not satisfy those requirements. They're essentially a one page or one paragraph letter, and there's no description of what area it is that you're talking about. They're not in recordable form. So I think you're probably going to need to get with whoever the legal team is that's involved in this project and have them draft that, because I noticed when I was looking over this stuff again for this meeting, that the document that was provided with respect to from Meyer with respect to the use of that their parking was signed off by the store manager. And I have serious doubts as to whether a store manager can legally bind Meyer Corporation with respect to the use of their land. And I think that there were other documents that suggested that the people that were providing the shared parking could revoke that at any time. And I think that I don't think the city would be willing to go forward with the reduced amount of parking if it thought that any one of these people could revoke their use of the shared parking at any given time. So I think there's some work to be done in connection with the shared parking for the extreme events, because if any of those properties were to change hands and there was not something that was a legal document of record, that new owner would be able to say, I know nothing at all about that agreement and I'm not bound by it. And I think the city of Fraser would not be approving this if they thought that there was some question about whether that shared parking those shared parking arrangements were in place and binding upon the parties. So there's some work to be done on that in the upcoming weeks.
So Mr. Andrews, would you recommend this is the way to follow by not joining these parcels?
No, I think that I'm okay with proceeding, but I wanted to make sure that Mr. Butler and the team were aware of the fact that they have some work to do to get these shared parking documents in order for us to approve that. And I don't want to be in a position where they get everything else ready to go and they are of the thought that they're going to get permits any minute, and we say, well, where's the shared parking agreements in recordable form? And they said, oh, we didn't know that they weren't all right the way they are. And I'm concerned about that because in each of these instances, somebody has to get the approval of somebody in the organization to do it. I mean, for example, there may be a question about whether the superintendent of schools, as opposed to the school board, has to approve a shared parking thing on behalf of the school district. I'm virtually certain that the store manager of a store does not have authority to enter into a legally binding agreement on behalf of Meyer. And the Lions Club probably has a board of directors, because most nonprofits do, and they would need to have a vote to approve the parking agreement and have the president of that nonprofit or whatever sign on behalf of it. And the stuff that was presented before was essentially a 1 or 2 paragraph document on a piece of paper, and it was not in recordable form, and there was no description of what property you were even talking about. So I just don't want people to be not addressing that issue and then finding out at the last minute that there's work to be done. That can be done while these other things are being carried out.
Thanks. Mr. Butler, do you understand what the city attorney is saying?
Absolutely, 100%. The attorney for the owner of the property is on the Zoom call. So we hear you loud and clear, and we understand your concerns.
The other thing I would say is I saw Mike Vigner on today at a function, and I asked his opinion about the importance of that, and he absolutely thought that was really important. And I asked Paul Erbiel that question, I think it was last Friday, and he said, I think we need to have the documents of record as well. And I think the Planning Commission prior action actually said that, but I just wanted to make sure there wasn't any misunderstanding as to whether or not those letters from those people that were not really legal documents, that those are not adequate.
We understand loud and clear.
Thank you.
Thank you, Mr. Andrews.
I have a question.
Go ahead, Commissioner Farina.
Why are they not combining that was a condition last time, was to combine the properties into one property and to do the parking on top of that? Why do they not want to combine the properties?
I think Mr. Butler or Ms. Kondravas can elaborate on this, but my understanding is that is to preserve flexibility to develop the north parking lot in the future, which I had mentioned would require it would require additional parking supply to move forward with anything occupying that parking relative to this proposal.
Exactly. You know, I'll tell you the truth. I think we're getting pushed around here for just, they don't want to do what they've agreed to do to get their site plan approval. And I think we should hold them to the original site plan approval. And I don't care about changing the building, you know, to what it is now. That's fine. But I think that they should be held to what they agreed to beforehand. This is a continuing saga with these people. You know, we ask for things to be done, they don't get done, they come back. We ask for the same things to be done. What our attorney just quoted is nothing different than Clark quoted a year ago to him. And it hasn't been done. Nothing has been done about, you know, combining the properties. Well, if they're going to develop the north parking lot, all of what they've asked for goes out the window. Those are my thoughts.
That's correct. And I mean, maybe the applicant might be able to expound on the requests, but yes, I agree that anything to take advantage of the flexibility that we provided by not combining the lots would require additional property or something else to manage the parking in the future.
Exactly. Then what is your recommendation, to disapprove this?
I guess understanding that that developing that property would require a new application, and that some parking supply that is not currently been identified would have to be part of a approval to develop the north parking lot. I had recommended that granting that removing the condition was okay if the easements are in place to obligate the north parking lot for the purpose of parking for the arena and for the project.
Mr. Chair,
Yes,
I just want to make sure I understand this. So if the north parking lot is not combined, the applicant then in the future do whatever he wants to do with that north parking lot. Is that correct?
Sell it off.
Okay, and not use it as parking. But what I understand, if we do the cross-access easement, that's good, but those cross-access easements can be withdrawn at any time also. Is that correct?
No, well, I mean, it depends on how they're written, but the intention of having them be recorded was be able to be modified or amended or withdrawn without the city's approval. And that's one of the reasons that I want to see what the documents say. Because
Okay.
if the city of, if for the sake of discussion, the high school believes that they can withdraw their shared parking arrangement at any time, that's probably not acceptable to the planning commission, because it was represented that there would be shared parking for
Right.
overflow stream events from the Fraser High School, and the same thing with Meyer, and the same thing with the Lions Club, and I think the intention would be that in the event that they want a modification of that they would have to apply for that and get approval of the planning commission before it could be withdrawn, because otherwise it's a pretty meaningless document if anybody can withdraw it at any time because they don't feel like having it continue to be in place. And that's why, and I think it's critically important that they be in recordable formats so that they do get recorded, so that future owners, in the event that the Lions Club decides to sell their parcel to somebody else, that new owner will know, oh, by the way, there's a commitment that property has to be available for shared parking for extreme events, and if they don't know about it, they're in a position to say, I'm not bound by that at all. So I understand that the Fraser Hockey Land probably has a good rapport with all of these various entities that may own the property at this point, but those things could change. I mean, I've seen instances where school districts decide to sell off part of their property in order to that they don't need all of it for, and if they decided to sell off an area that was going to be an area that was used for overflow parking, that would create a problem. Or if the Lions Club said, we're just too busy using this site ourselves and we can't any longer make it available. Well, the city of Fraser and the planning commission needs to know about that, and I think the document should be written in a way that basically says that if they don't have that overflow parking, that approval is no longer in force, because that was as I recall it, at least that was a critically important thing from the planning commission, because they were very concerned about parking on that site. There were a number of members that said parking is really tight there, and the applicant explained that it was really tight only very few times a year, and that the planning commission worked through is calling those extreme events, and that they had worked out provisions to have overflow parking at different sites for those extreme events. And but I think it was everybody's intention that we would know what the terms of that were, and that they'd be legally binding obligations of the property owners of each one of these places, the school district, Meyer, and the Lions Club. So I just want to make sure that there's not any misunderstanding about that, or because I can tell you from my dealings with school districts and organizations like Myers in the past, it takes time to get things approved through those organizations. It's not like you can say, well, get us a document approved so that we can close on Friday. That's not the way it works. It takes sometimes weeks and sometimes months to do that. And I'm sure that once Fraser Hockeyland gets the rest of this stuff in order, they're going to want to move forward. And I don't want these supplemental agreements to be an obstacle to that, but I also want to make sure they're in place.
Clark, was this the properties that we were looking at, condominium kind of structure for the properties?
Yeah, we did talk about that at one point, and we talked to the attorney involved in that, and they didn't pursue that in any way, shape, or form. But you're correct.
Then if they're not willing to pursue what we've asked them to go do, why should we grant them? This is my opinion. Why should we grant them anything?
Well, I think the answer to that is that if there's a satisfactory alternate thing provided, and I think what happened with respect to the condominium side of
Clark, you're frozen.
that one of the people that was going to be involved in that didn't want to do that, and Mr. Butler altered the site plan in order to provide access so that we didn't need that next door neighbor's involvement in that, and the planning commission said that was okay, and I felt comfortable that dealt with the problem. But as it relates to this shared parking situation, I feel that that's been sitting kind of idle for a long time, and part of that was because the project was kind of idle, either because of COVID or because of the fact that there was, I think that the outlot across the street moved forward faster and got some of the tenants that Fraser Hockeyland was maybe thinking they were going to get and so forth. So it was not really on a fast track for quite a long period of time. And I think it was Mr. Butler, I think, can attest to that it was only recently that it was kind of brought back to the front burner. But that issue of the shared parking thing and the need for legally enforceable agreements, that has been on the table for quite a long time. And
since day one.
Yeah, I think that's pretty much true. And I wanted to make sure that nobody was under any misunderstanding about whether or not those one-page letters that had no description of the property and weren't legally enforceable documents, those are not satisfactory, and I want to make sure that people can get going on that. And I think I was told quite a while ago that they were going to do, rather than doing it piecemeal, they were going to do, kind of a reciprocal document or whatever. And I said, that's fine. All I want to make sure is that it's legally enforceable and that it gets recorded so that future property owners will be aware of it and that they won't be able to revoke the approval without involvement from the city.
Can I ask a question then of the applicant? What are they doing about that? And why hasn't it moved forward?
Mr. Farina, Altaniaki and Dravis, I'm the attorney for the applicant.
Yes.
First of all, I just want to offer my condolences to the commission on the passing of your commissioner. I'm sure he was a great man, and I just want to offer my condolences to all of you.
Thank you.
The original application encompassed a parcel in the front that had two properties on it. Just so everyone goes back to the site plan was then revised to only accommodate for one building versus the two that originally proposed. So we are not taking away the front. If you're facing Fraser, the front right parcel or the front right portion that we were originally asking for in the site plan. So the site has been reduced, the size of the site. So we have allowed for parking on that also, that additional half of the front parcel. The north lot that we're all discussing, that will also have a shared parking agreement. I understand, Mr. Andrews, your concerns, and we have every intention of putting a shared parking agreement in place. The parking agreements will be in recordable format. I am in the process of drafting those now to get them to you, Mr. Andrews, to review. I'm gonna reach out to Mr. Butler and make sure that I have your contact information, or I can just look you up on mishpar.org and find your contact information so I can send you the documents that you're requesting in order to get this, hopefully this process through. The delays, I can't speak to the delays in terms of moving forward on the project, but it has been revised significantly and reduced in size from the two buildings to the one, which has required further engineering, further planning, further architectural drawings. So we have
The parking agreement has not changed, and the requirement for that has not changed in a year. Why hasn't that moved forward?
to put them in recordable format. Is that what you're asking me?
Yes.
Yes, I'm drafting those right now to put them in recordable format.
My
The
question was, why haven't they moved forward in a year?
COVID has had a big play in this, to be honest with you, Commissioner Farina. COVID has had a big hindrance on our operations and our ability to do this. So that may be the reason as to why. A year would have been July of 2020. So we were in the thick of it. That is my intention, to get every document to Mr. Andrews for approval. And obviously the site plan, if it is approved, would be conditioned on those agreements being reviewed by Mr. Andrews. I understand his concern, but if those documents aren't produced, then we can't move forward anyway. So in essence, Mr. Andrews' approval is very, and the city's approval obviously is ultimately important for us to move forward on this project, which we dearly want to do.
Mr. Farina, I will say one other thing, and that is if the project parameters in terms of what they were going to build and so forth was not as it was originally determined, that could potentially impact the amount of overflow parking or any type of parking that they were required. So I understand that until they got to the point where they knew how many buildings they were going to have and how many square feet there was going to be and so forth, and what the uses were going to be, it perhaps was premature to finalize all those agreements. But that being said, I wanted to make sure, and I think everybody understands it because I've said it several times, that's having recordable documents that are legally enforceable with respect to that shared parking is critically important to, I believe, to me and as well as to the planning commission. And if we can't in the city, and if we cannot get those because any of these organizations are unwilling to provide them in a recordable form that are legally binding, then they don't have an approval. I mean, it's just as simple as that.
And Mr. Andrews, can I make one more point in terms of future development of the North Lot parcel? If any future development is to take place, obviously we would be in front of you again for any development and would require additional land. We understand that a shovel would not go into the ground until the Planning Commission approves any future development on that North Lot parcel.
And your project
I
planner that's there, has anything been done on the parking lot to correct the deficiencies in the parking lot over the last year?
I can actually answer that, Commissioner Farina. The parking lot is actually scheduled to be repaired in the middle of this month. The bids have gone out. We've accepted bids, and it is on schedule to, I believe, the 14th or the 15th of this month.
Thank you.
Chair, can I ask the applicant or its attorney, is that north parking lot necessary to meet the reparking requirements?
Yes.
Yes. Okay. We have asked the applicant to have these parcels combined from day one. It was completely understood from the very, very initial application in front of the Planning Commission. My thoughts are on the same line as Commissioner Farina. Can I also ask the applicant, why are we taking out the outside seating? What's the rationale behind that?
It was the desire of the owner to have 4 seasoned seating inside the building.
Oh, can you describe what 4 season is? Is it going to be like an enclosed atrium?
It's going to be fully enclosed, Ms. Sarnacki.
Okay.
It's going to be a fully enclosed building.
Thank you.
If we're keeping the same footprint, Mr. Butler, how did we gain 54 square feet?
Just the way the layout of the patio was, and when we put the building on top of it, there was a piece of curvature in the patio area, so we squared those off for the building.
So it didn't change parking setup or anything?
It really didn't change any of the parking setup at all. It just what was within kind of the building pad, and the pad burst with the building footprint and the patio.
Okay. Any other comments? I noticed nobody's even talked about the facade and all that, the outside elevations. Is there anything different at all? Or is it just going to be continue what was the rest of the building?
It continues what the theme of the building that was approved back in June.
So it's not going to stand out with something that just sticks out like a whole big change in materials.
No, it's consistent with the materials and architecture are consistent with what you saw in June.
Okay. Anything else? Have we, I know we went around this parking in that or in splitting or combination of the lots. Do we have any comments from you that, you know, that would answer the board's desire to go back to combining these rather than keeping them split? Any reasoning?
I mean, we're proposing to keep the lots as they are. We are proposing to have reciprocal agreements for shared parking, utilities, and alike. I mean, I look at it somewhat similar to the previous applicant who was in front of you about doing the same thing. They weren't required to combine their lots. They're just looking for some more flexibility for future. You don't know what the future holds, but they'll be still under a reciprocal easement agreement. They'll combine them.
There were 3 lots involved before. There's still 3 lots involved, or is it down to 2?
There are 3 lists. This property makes up of 3 lots. The biggest one being where the arena physically sits. And then there's 2 parcels that are on the north. So the bulk of the parking is on the larger parcel.
Well, do we have an aerial showing all the 3 parcels? There we go.
Yeah. So the bigger portion of the ice arena property is the biggest piece. And then there's 2 tax parcels that front on Wood Lane. There's a small slivered parcel that's to the east and to the west, and then the larger parcel. And that's all parking, just parking, general parking area.
So really, it's just those two on off Wood Lane that you're talking about not joining. The rest is all one parcel still,
Correct.
where the restaurant sits. That really isn't, there were no division lines on that last drawing.
There is a plan to do, there is a division line to subdivide that parcel off.
The condition before was that everything would be combined and then before the division of the outlot would proceed to maintain the north parking with the arena area.
So, but we are talking about keeping these three parcels, these three parcels that were going to be joined as now the original three parcels.
Correct.
Okay, so I think I was confused with that. The restaurant, looking at that, can you go to that previous drawing? So when you're looking at that, it kind of, I don't understand the drawing back at the back, going back toward the arena. If that was a lot line around there and that.
There, if you look at the plan, you'll see kind of a heavy dotted line, Paul, if you can run that down.
There.
That is
Yeah.
what we're proposing as a division
Okay.
of the frontage brace.
Okay, so the heavy line. Got it.
Yes, yes.
Okay. Yeah, I think I was confused with that. So the dumpsters would still be on that site. Everything for that restaurant would be on that site except parking that's shown. So
Right.
Back to the shared agreement then.
Correct.
Okay.
Correct.
Okay. So we get any feel on this? Any more members? Have anything? I think it's a little, it's really confusing, I think, to most of us of what not combining these lots is going to do and not do.
Mr. Chair, may I
Yes.
offer?
Yes,
Alton
Kendrivas.
Yakandrivas again,
Yep.
The attorney for the applicant. The not combining the parcel in terms of the parking arrangement will remain the same. We will continue to have a shared parking agreement, a reciprocal parking agreement with the larger parcel. So in terms of affecting parking, I don't believe it will affect the parking arrangement at all moving forward as it relates to Fraser. The use of that for any of their parking requirements or overflow parking, whatever you want to call it. The reason for the request not to combine the properties is so that in the future, if we were to do something, that property would already be split off, and then we could work with the planning commission to develop a site plan that would work for all the parcels together. We would not want to endanger the operations of Fraser Hockeyland whatsoever, nor would we want to endanger the operations of the proposed restaurant in the front of the property. What we're trying to do is bring a little bit more exposure to that property, bring a little bit more visibility, and bring a different customer base to both those entities, to Fraser Hockeyland and to the proposed restaurant in the front. We have a significant investment, or we want to make a significant investment in that area, which also would include possibly in the future developing that north parcel with additional property. Obviously, we would not be able to do that without that. As I said earlier, the original site plan did have 2 buildings on it. We're only doing the 1 building now, which decreases the, which would actually increase the ability of parking spots on that property. So we're adding back parking spots that we were originally wanting to take, which is why the combination, I believe, was part of the discussion. Since we are leaving half of that front parcel with the original property, I think it's more of a swap, but we will still continue to honor those shared parking agreements with Fraser Hockeyland and the operations of that property in general.
Okay, does everybody understand that? I mean, looking at, is there an actual agreement has to be between, these are all have the same ownership. So if these are left alone, we need agreements between themselves, basically. Absolutely. For these parcels. And in that parcel, how do we know that's not going to be tried to be developed and use up all this parking spot that's required? You're saying it would need to purchase other property to maintain the required parking?
The presumption I'm working through, Mr. Chair, is that if the property were to be developed in the future, it would go in front of site plan. Obviously, any recordings that were on title would remain. And that would be a condition, I would presume, site plan approval for any future developments, that additional parking be provided for Fraser Hockeyland or for the operations. So that, I believe that would be a requirement moving forward regardless, that more property would have to be purchased in order to accommodate the parking requirements.
Okay, excuse me for adding, I'm just trying to make clarification for all members
Absolutely.
of where we're, as we make our decision. Does anybody else have anything they want to add or question?
Clark,
Yes,
what's your technical recommendation? Your legal recommendations?
I'm not against going forward with it with the condition that no permits would be issued until all of the conditions of the planning commission approval are satisfied, including the one that requires these shared parking agreements in recordable form and satisfactory to the city attorney and the city planner. For purposes of clarification, it was my understanding, and correct me if I'm wrong, was that the planning commission believed that the parking for Fraser Hockeyland site was inadequate for extreme events when they had a lot of people coming, and for those events they had to have the ability to provide off-site shared parking from these 3 or 4, I think it was 3 different entities, and that there needed to be a document in place that was in recordable form that showed that understanding or agreement was in place, and that it wasn't contingent upon what happened on development down the road with only the Lions Club site. I thought that it applied to extreme events when there were going to be a lot of people there, irrespective of whether the Lions Club was being redeveloped or not. And if my understanding is incorrect, then I want to know that.
No, that's correct. And the June approval reflected the 1 outlot building instead of 2. And the engineer's analysis acknowledged that the reduction in the outlot buildings meant that everyday operations were now in line as it stands, but extreme events would still require the shared parking.
Right, and I feel that that even if it only applies to the extreme events, I believe that document needs to be in recordable form and make it clear what area it is that we're talking about, so that somebody doesn't sell off part of the property that we are relying on, or encumber it in some way with a carnival at the same time that Fraser Hockeyland needs extreme overflow parking, and then have us be in a situation where there isn't any parking. That was my understanding. I mean, we spent a lot of time discussing the shortage of parking and whether there was going to be adequate. And it was only after there was a lot of discussion about the fact that the excessive need for parking only occurred a few times a year at these extreme events, and that most of the time the parking was adequate. And I think that applicant convinced the planning commission that that was satisfactory, but we wanted to make sure that there was a mechanism to take care of the overflow needs during those extreme events. And we wanted to make sure that there was written documentation in recordable form that showed that that was in fact the case. And so far, we don't have that.
Okay.
And I want to say one more thing, and that is that when you get other organizations involved in this, they may be concerned about what the definition of an extreme event is and so forth. And I think that I don't think that it's necessarily that this shared parking thing is something that can be solved in an exchange of one or two drafts. I could be wrong. I'm hopeful I'm wrong, but I know that when we went through some of the cross-access agreements and other things relating to the Meyer outlot development, that it took several exchanges and interchanges of documents before we got where everybody was on the same page. And I expect that may very well be the case with respect to this one as well.
Clark, this is something new with this extreme event. And no matter how we look at it, it could blow up in our faces. It might work beautiful. We
Correct.
don't have a crystal ball.
No,
So how do we kind of cover ourselves if it needs to be changed? See, we can go around in circles forever. Some saying this ain't going to work, others saying it is going to work. I guess we don't know till it actually happens.
Well,
I understand that. Go ahead.
they have to abide by all of the conditions that we listed. And all of those were meant and said they had to hire Fraser Public Safety for traffic issues and for crowd control and whatever.
Mr. Commissioner, may I speak?
Yes, go ahead.
Hi, Bud Kowalski, General Manager of Fraser Hockey Land. I
Hi,
appreciate
Bud. You've been awful quiet.
It's unusual for me, Commissioner Farina, but yes, I have been quiet. I agree with everything Mr. Andrews has said 100%. The last time we got together, my notes say, not only did we agree to get him in a reportable form, but we also said that we would reimburse the city attorney for any review and appraisal necessary to make sure that we took care of his expense, and that was our issue. Also, just to reiterate the agreement that we've had, and as you all know, this has gone way back longer than any of us wanted to. It does say the extreme event A has to be in excess of whatever number we agreed to, which is 1575. And the other thing it says, which is the first bullet point, says I have to ask you guys for permission. And if I go to you and you say, you know what, we don't want to let you do that, then we're done. And then once I get the permission from you, then I have to go ahead and go down, notify the public safety, notify the Lions Club and all that. So you guys made me jump through all kinds of stuff to say, if we do this, and just because I schedule something, if I go to you and you have to have 60 days notice, and I go to you and you guys even told me who I have to talk to. So if it's not going to happen because you don't want me to, we're done. But please be assured that in the 4 years I've been here in this position, and in my kid's in 84, so I've been in this building 31 years in some capacity. The number of extreme events is less than 5. All right, since I've been here. And I can tell you that I can't speak to what happened before I got here when there was a pro team, and I understand there was people scalping tickets and people parking across the street at Myers when the NHL was on strike and they had all these players. But this is definitely something that I have to get your permission from. I have to make sure, as I think Mr. Andrews said, if there's a fair going on someplace else or something else where it doesn't match up, then we just tell the extreme event people, you can't come. So, and that is definitely the exception. And as everybody's agreed to, I believe, in the day-to-day operations, we don't have a problem. Thank you for your time. And I do have a bike rack, by the way. I guarantee
Good man.
Thanks, bud.
that was from way back when.
Okay. Well,
Any other input?
Mr. Chair, I still think we're discussing the 3 parcels, whether they should be combined or not. And the city combines lots, they split lots. In the future, that lot could be split also if we had the requirement that they be combined. I'm not understanding the concerns of the applicant to not combine the lots.
I think there's some assessing things in that don't allow you to split and combine so much. Is that right, Mr. Andrews? That you just can't go splitting and combining. You only get so many.
Right, but depending on the size of the parcel and during a certain time period and so forth. So that may be part of their concern, is to preserve their flexibility with respect to that, if in fact that other parcel is going to be incorporated in a different fashion than it is now.
Okay, thank you.
So let's get this for the board members. What's the
Wait.
negative? What's the negative and what's the positive? Why go one way and not another? Or is it really going to hurt us at all to leave these and not combine them? I just want to play devil's advocate, get everybody on board here. Go ahead, Commissioner Farina.
Maybe Kathy can shake my memory, because I don't know that you were on the board then.
No.
But didn't the assessing office come to us and ask that they be combined? Am I remembering that correctly, or is that?
Commissioner Farina, I don't recall that. I do recall Mr. Affer being very specific during our first meeting that he did not want to combine the parcels. And I do remember citing to him after approval was granted that he understood that we were asking that the parcels be combined. That is what I remember as chair.
Okay.
Okay, but in the future, you just can't go splitting and combining and keep changing things. So
Okay,
we
that
got to
I
look.
understood. Thank you.
So
Okay.
we have to look at this for the long term and what is the best way. And it's really, does it affect us at all? Whether we leave it the way it is right now or combine them.
If I may, I think it does put more pressure, or it is more incumbent on the administration and to ensure that the shared parking agreements provide the same result. Because I guess if it in the future the lot could be, if it's combined, the lot could be split. I think the number of divisions is 4 that you can have. As Mr. Andrews said, it depends on the history and the size of the parcel, but I don't know that particularly is an issue for one combination and then one redivision. But
No.
I guess it's just a matter of our recommendation that it could happen was sort of based on the same result relative to parking being achieved. Without a full understanding of why the applicant can't. They did submit an application to combine the parcels last year, I believe, but withdrew it prior to right around the time of the June approval.
So originally, was it discussed that this is what was wanted, or it was just submitted that way?
I mean, I think
because I wasn't, like I said, I'm trying to get myself up to speed more from the past, that I don't know that history on that part.
And in some respects, I'm in the same boat, but I guess
yeah.
from my point of view, the the reason that that parcel, the reason that that parcel, I assume that the reason the parcel was asked to be combined was to ensure that that parking, which has always been tenuous throughout this process, that there, whether or not there was enough parking, to ensure that parking was available. So my line of thinking was, if the shared parking agreement can ensure that that parking is still available even with a change of ownership, then
There shouldn't be any
the
difference.
previous context aside, the result is the same.
The result's the same as long as it's enforced, that, and that's the way it's got to be written up and recorded. Once it's recorded, nobody can buy that parcel and all of a sudden build something there. Well, they got to come to us no matter what, but that parking has to be provided there. So
That's correct.
So really, I'm just trying to get a good understanding of this. What's the difference from leaving it as is, as opposed to combining? I'm wondering, is it really something that we're beating a dead horse here on, or, you know, if we're going to get the same end result, what's the difference?
Paul, let me ask you a question. Was it your understanding based on the most recent site plan submission that, and the comments that you received from Mike Vigneron, that the parking there was adequate, except for the extreme events, or were there instances where the parking without those shared parking arrangements would be inadequate, even in the case of day-to-day regular events?
So the analysis did not contemplate that the north parking lot was not in play. It assumed that the north parking lot was included in the parking provision. With the north parking lot, the analysis, when the proposal changed from 2 outlot buildings to 1, the recommendation or the analysis said that day-to-day that proposal would work, which includes the parking on the north lot.
Is that green one that says 186 spaces or whatever?
Yes,
Correct.
yes. There's those 2 parcels that
correct.
make up they say Wood Lane Road with the parcel number. That's correct.
And is that the parcel that they don't, I mean, that's one of the parcels they don't want to combine, or is that the only?
The
parcel?
request is to not combine those 2 parcels with the larger parcel before yes, that's correct.
When you say the 2 parcels, you're talking about the Wood Lane Road 11312280002 that's on that drawing, and then the Lions Club to the
No,
west.
sorry, 22801 right here and 22802, which together make up the north parking lot.
Where's the other? I thought you said there were 2 parcels. So
That is too.
There are 2. This line right here, if you can see my cursor, there's a long skinny parcel here and then a wider parcel.
Is that? Oh, I see that it's 100 and whatever, the 106 shared parking would involve the Lions Club, but the question of combining applies to 11312280001 and 002, right?
Yep, the previous condition was that 001 and 002 were combined with the main Hockey Land parcel before the outlot was divided from that now one parcel.
So
but 001 and 002 were always parking from day one, from when this was constructed.
Correct.
So it really doesn't change anything for those 2 parcels. It's still going to be parking and same ownership. It all comes down to the future of what happens down in the future, change of ownership or something.
Correct.
So right now it's always been parking and it's staying parking.
But if those 2 parcels are independent parcels of record, then then conceivably those parcels could be sold to somebody without there being a land division from the city, because those are already independent parcels. So from that perspective, this city has a little less look-see of that. And what Paul Urbiel said earlier was the administration needs to be a little more diligent, because of the fact that if it's one parcel and they want to get rid of it or use it for something else or whatever, they have to get the city's approval through the land division process. Whereas if those are separate described parcels that are independent, and then it's a tougher monitoring situation, because let's say, for the sake of discussion, there was an agreement in place that said that those properties could only be used for parking unless the city signed off on it. If somebody ignored that agreement and went forward and did something without the city's approval, it would be a tougher enforcement situation than if it were all one parcel. Because if it were all one parcel, then if they want to do something separate with either one of those two parcels, they would have to go through a review process with the city that they couldn't get around.
But the parcels were subject to a shared parking agreement with the larger parcel that would tie those together.
I think that's something that would be worthwhile. I mean, I think that,
And we're agreeing to do that. That's exactly what we're agreeing to do.
And that is, I mean, I guess in a sense, there were two things that I was looking for. One was that, and then with respect to these things that are under other ownership, that were going to be looked to only in the event of extreme events, we wanted to have a document in place that clearly recognized that the other parties that are involved in that recognize that they were making a commitment to the Fraser hockey land, that they would have part of their area available for parking and for extreme events. But I think if there's a recorded document that clearly makes it clear that there's a shared parking arrangement, and that and it's recorded, then somebody wouldn't be able to do anything with either one of those lots without taking into account the shared parking agreement, because that would be binding on them, just as if
But Clark, if they come to,
been a party to it in the first perspective, to make sure that these are good. Go ahead.
if they come to us and say, I want to do something with this property, are we going to have vision that there's a shared parking agreement? If somebody just came up and said, hey, I want to build something on this property, I'm not here, Randy's not here, Kathy's not here, Kenny's not here, it's a whole new board. Is that board going to have sight that can't be done? Or is this a way around?
I guess I don't know exactly how the internal, but I would think there'd be some safeguard in the city records that would make sure that somebody knew that there was a shared parking arrangement with respect.
Okay, then let me ask Paul. Paul, how do you safeguard that?
So the conditions would be recorded in the city's records, and the way that it should happen is that the future administration, when considering that an amendment to that site plan, would find these records that say that this board imposed those conditions, and would require that that parking was provided elsewhere, or that considering new information, nothing could go forward unless that was satisfied or amended.
So if somebody came buying it, they'd see it in the deed restrictions that it is parking. It's got to remain parking. Why would you even buy it? Unless you're going to start selling parking spaces.
No,
Well, I think the answer to that, Randy, is that you as a relatively sophisticated real estate person would not do that. But I can tell you there are instances where people buy land without doing a proper thorough investigation, and they buy it and then they find out after the fact, and then they come to the city and say, I had no idea that this was there, and I paid good money for this parcel, and I want to be able to use it for something, and now you're telling me that I can't. And but shame on them for not doing their due diligence. But those are the things that sometimes come up. I mean, I would never buy a piece of property without getting title insurance and taking a look at the documents that are recorded against that property. But there are lots of other people that do all the time. But from a legal perspective, whether they read them or not, they're bound by them, because if they're recorded and they have notice of it. And that's why it's so important that we not rely on an unrecorded agreement between two parties. It's not a matter of record.
Mr. Andrews, I have every intention, I apologize, Altaniaki and Drivas, every intention of providing you those documents for review before they're executed by any entities whatsoever. That way, upon your approval, the entities at the same time can look at them and make sure that they're to their standard as well. And once they become a part of title or chain of title, anyone who purchases property would have record notice of any easements or any agreements of record affecting that property.
I completely agree.
So there would be a record of that. Absolutely.
Okay.
Okay, do we beat this enough, or?
Yeah.
Anybody want to make a motion or anything?
Sure, I'll make a motion that site plan 21-08, Jim Butler on behalf of A&A Management, part of the 33-400 Utica Road proposed site plan amendment be approved with the 12. You don't want me to read all these, do you, Clark?
No, you don't have to.
With the 12 conditions as cited on Mr. Herbel's report dated 7-27-21, with the additions of condition 13, which is the city's attorney's office will be reimbursed for all costs associated with the parking agreement review and approvals. And 14, that no permits are to be issued prior to the executed and recorded cross-access shared parking and utilities agreements.
I support.
Okay, so we have motion, Commissioner Farina, support by Commissioner Zarnecki.
You understand there are now 14 conditions.
Yes.
Okay.
Okay, any questions by any of the other board members regarding this? You all understand it? All right, let's take a roll call vote then.
Commissioner Barr,
Yes, with the conditions that I hope will be done in the future.
Commissioner Zarnecki,
Yes.
Commissioner Farina,
Recommendation of you and Mr. Anders, yes.
Commissioner Perry,
Yes.
Commissioner Warnick, or
Yes.
Chair Warnick, excuse me.
Yes. So that motion carries. And thank you for your time, Mr. Butler.
Yes, thank you, members. Appreciate your time and your good discussion this evening.
Thanks.
Thank you, members.
Bye-bye.
Thank you, Ms. Cantrias. All right. think we got that done. Only took a few minutes. So let's move on to unfinished business.
We're gonna call you Mark.
What's that?
We're gonna call you Mark Steinach.
Yeah. So unfinished business 01-19 SUB, Max Mancini, Garfield Park subparcels 1 through 10, proposed site plan amendment. Is Mr. Mancini out there?
Yes, I'm present.
There you are.
Oh, Mike.
All right. So let's start with background info on this, Mr. Urbio.
Yes, so in February of this year, the Planning Commission considered a request from Mr. Mancini. It actually was taking it back up, had been postponed since 2019, to revise the approved site plan for the Garfield Park development. The 2006 site plan was for the development of 10 single-family residences on Anita and Josephine Avenues east of Garfield. 9 of those homes were constructed, but the 10th one was not. The request to amend was that the site plan be amended to not construct the required extension of Anita Avenue past the middle of parcel 4, and a request not to construct the approved Anita Avenue home on parcel 5. At that time, the discussion in our recommendation was that we didn't see a way that granting this amendment would be in the city's interest, because what would result is an unbuildable parcel on parcel 5 that did not have access to utilities or road frontage. So we didn't see a way that the city could approve that, leaving that parcel as non-compliant with the zoning ordinance. After discussion last time, the commission voted to postpone this matter for 6 months to give Mr. Mancini time to combine the parcels prior to this meeting. So it was postponed to the date certain of August 4th, so we're back. Our letter at the time it was issued did not have any new information. So again, with the parcels not being combined, we were of the same opinion that what would be left if this site plan amendment was allowed is an unbuildable parcel that's not compliant with the zoning ordinance. You got my email Friday of last week with that Mr. Mancini providing evidence that he had sold the parcel to the owner of parcel 4. So that seems like progress on this matter. I think the administration is of the opinion that that's good progress. We think maybe we need one more meeting to ensure that the new owner of the parcel is aware of this matter and intends to combine the parcels. If that's the case and the new owner can combine the parcels, then the problem that we saw is alleviated, it's removed, and we think the site plan could go forward. Or the amendment could be approved if the parcels are combined.
So you're recommending we table this? Is that what you're saying?
I am, yes.
Mr. Mancini, can you give us your name and address? I'm sorry, I should have got that first.
Sure, Max Mancini, 41744 Stonehenge Manor, Clinton Township, Michigan 48038.
Before the board questions you on anything, that can you add to anything Mr. Urbio presented? Anything different?
Well, I just question a lot of times the statement of this property being an unbuildable parcel. It's just not a developed parcel on Anita Drive. It is buildable. It has access to road frontage. It just doesn't have it developed yet. I think having it platted as it was originally platted almost 100 years ago gives it future access to be buildable should the Anita Drive be developed in the future. There's an identical parcel right next to this parcel here that was purchased by Mr. and Mrs. Crow, who live on Josephine, the backside of the parcel. They haven't combined that parcel to their lot, and they're maintaining it. I believe the purchaser of lot 4, parcel 4, 17088, Anita, who had just purchased this property last month, a few months ago, and purchased the vacant lot that's in question right now, is going to intend in keeping it, maintaining it from having high grass, weeds, and so forth, just as the parcel next to it that was purchased by the adjoining landowner from Josephine. Having it combined, I don't think makes a difference in the maintenance and the aspect of this property. I don't know why that has to be such a fact. It is a buildable parcel upon the development of Anita. If we do combine it, then it will not be a buildable parcel.
Any questions from the board?
So nothing has changed from a year ago.
Well, I've
Except
done
ownership.
everything except ownership. I've done everything the planning commission has asked me to. I mean, in the first meeting, they've requested me to find access for emergency vehicles. And then I did a lot of due diligence and presented the board the fact that there is access on the undeveloped or the paved portion of Fraser Drive that is part of VFW parking lot. And then the planning commission asked me to sell the lot to the next door neighbor. And I tried to do that, and the next door neighbor then sold his house. And I had to pursue that with the new owner, and I did. I sold it to him at a song, so that it will be maintained. I don't know what else you want me to do.
Mr. Chairman,
Yes, Mr. Andrews.
normally when a parcel is platted, normally the utilities and the street improvements and all that go in before somebody gets final site plan approval. I'm not, final plat approval. I'm not certain as to why that didn't happen in this particular instance, but we are now left with the parcel that unless that road is extended or unless water and sewer are extended, that parcel is not buildable. And I think what the city believes is that if it is not buildable and Mr. Mancini is not willing to extend the road or extend the utilities, which was a condition of his original approval, then the city believes that the best protection to make sure that
We're losing you, Clark.
nobody thinks that that's a buildable lot, and to make sure that the property gets maintained so that it could be sold and combine a parcel that didn't have frontage on a right now.
Clark is gone. I can't hear.
Yeah, Clark, we can't make out
If it's
your,
kept as a separate frontage on a public road and it is not served by what?
Clark,
and it is not.
we
it
didn't
is
get your full, we can't, you keep cutting out and we're missing all of what you're saying.
Sorry, I don't know. I think that there's something on my end that's causing that. But anyway,
You're good now.
I think that it's important from the city's perspective that if that lot is not buildable because it doesn't have frontage on a public road and it doesn't have public utilities, water and sewer extended to it, I think the city believes that it shouldn't be a separate lot like it was, because it won't be maintained. The person won't pay the pay the property taxes, and then the city will become the owner of it, which the city doesn't want to have a parcel of property that it's responsible for maintenance of. So I think the planning commission was a mindset that if Mr. Mancini could sell it to the adjacent property owner, then it could be combined, and we would eliminate the problems that were associated with it. And I discussed this with both Mr. Urbiel as well as with Mr. Vigneron, and we were all of the opinion that they needed to be combined as well as sold to the neighboring property owner.
If I may address that, Mr. Andrews, there are 3 other owners of properties on that section of Anita that you're talking about that was platted back in the 1920s, I believe. I purchased this property that well after it was platted. I did not plat this property. And those 2 other owners that also own it adjacently, identical situation as I am, have not been forced to combine it with their adjoining lots. So it seems like it's a different set of rules for this individual lot that we're talking here, as opposed to the other 2 lots.
Except for the fact that you got a site plan approval from the city that had conditions that included that you were going to extend the road and put in these utilities. I don't know what the conditions were with respect to anybody else, but with respect to your particular 8 lots or 10 lots or whatever it was a condition that you would do that, and you understood that when you got the approval and you intended to do it. And it was only after you got 8 of the lots sold or developed that you decided that it was too expensive or you didn't want to have to do that. And the question before the planning commission is whether or not they are willing to amend those conditions of the original approval to eliminate the requirement that the road be put in and that the utilities put in. And it's their decision as to whether or not that's going to happen or not. And I agree that you've made some good efforts in order to eliminate this problem by finding a buyer to buy that. But I think those parcels need to be combined in order to because the person that owns the property next door that just bought that, if it's one parcel and he's not going to not maintain that and run the risk of losing his home because he didn't take care of the property. But if you decided down the road that I don't really want to be bothered with that, I'm just going to where did you lose me? I lose you. I mean,
Probably 30 seconds ago.
All right. What I said was that if the parcels are combined, that new property owner is not going to run the risk of losing that property by failing to take care of it, because his house is on it and he doesn't want to lose his house. But if that is a separate described property and he just says, you know what, that's too much trouble to maintain that property. I only paid $5,000 for it. I'm just going to let it go. I'm not going to take care of it, and I'm not going to pay the taxes on it. And ultimately, the city becomes the owner of that, and the city doesn't want that maintenance headache. So if it's combined, we don't have that problem.
I understand your concerns, Mr. Andrews. If we go back, this is before you were with the city, when the site was approved and each individual lot was being built on, I had a good working relationship with the building department, and it was well understood and conditioned that prior to me getting a building permit, which I did for those individual 9 lots that were built, I had to develop the infrastructure in order to receive a building permit. And I did individually as time went on. It was my understanding, and it was fact, that the infrastructure would be developed per lot individually, and then I would receive a permit for it. And nowhere in there did the building department say, you need to develop everything before we give you a building permit. They said just build. It was understood that the development of that lot would be completed prior to receiving a building permit for each individual lot. And I even discussed it with the building department, but that last lot, as time went on and we discovered other things with it, that the lot that was in question was probably not going to be developed. It was going to be left as it is, as it was platted back in the 20s. When the lot on Anita, vacant Anita, that was purchased by Mr. and Mrs. Crow, they were not forced to combine that lot with their lot because of the same exact conditions that we have here, and they're maintaining it. There's always a risk on any of the vacant lots that someone's not going to maintain it. But that doesn't mean that we're going to force the adjacent landowner to combine it in order to remove that risk. And then there's a great reward too. If we don't do that, and let's say that the city decides to develop Anita or sell the park that's on the other side, on the north side of the Anita Drive that we're talking about, then the city of Fraser will benefit by having another home built on that lot. If it's combined, we're going to remove that option, that future option that can happen.
I don't know, if that property, if the road were to be extended in the future, I don't think the fact that those were combined together would preclude the owner of the person that you sold it to from coming to the city and saying, this now is a buildable lot, there's a street, there's utilities there, and I would like to eliminate the combination. I think the city would approve that, but right now that's not on the books, and I don't know of there being any prospect of that happening in the near future.
I also want to bring to the Planning Commission's attention that this understanding of me not building this lot was well agreed upon with the building department. Upon change of building official, which happened in 90% of the 17088 being developed. The only remaining inspection that I needed was the final inspection. All other inspections were done under a different official. And that's when Mr. Wright came up to me and proposed that I needed to get this site plan amendment before the Planning Commission. So it was never brought in front of me until the last hour of the full development that was going on for over 10 years. And I did everything I can to fulfill all of the Planning Commission's and Mr. Wright's requests. I can try to have the owner of this lot combine it, though I don't see it as advisable, but I can make that request to him. But that's strictly up to him whether he wants to accept it or not.
Mr. Chair.
Yes,
Okay.
Commissioner.
Mr. Mancini, I am looking at the minutes of the Planning Commission meeting of February 3rd, 2021, when you brought the same application before us. And we agreed, it was approved to postpone your item. And I'm reading specifically from the minutes, depending if the applicant is able to combine parcel 4 and parcel 5 prior to August 4, 2021. So when you state that you don't know what else you want the planning commission to do, that's not fair to the planning commission. We made it very clear to you. If you can sell parcel 5 to parcel 4 and combine them, come back to us.
Well, I did sell parcel 5 to parcel 4.
I
And that
understand,
was
but they're not
after the
combined.
owner,
I understand.
well, I can bring that up to the, right. You also, I think everybody knows that my initial agreement with the owner, after our meeting, I went to the owner and started working on that agreement. And we started in the process of that. And then in January, he called me up saying that he had a new job down south. He was going to sell the house. So everything I had worked up to January, I think February, he called me and he said he was going to move down south and sell the house. And he did. And then within 2 months after the purchaser bought the new house, or after he didn't move in until 30 days after, and I finally was able to get in touch with him, I was able to put the sale together. But for me to combine it in that short time frame was almost impossible.
Okay, is it possible that you can go back to the owner? I understand
I
it
can
being
go-
on sale. I did see the sign up for sale and I'm thinking, whoa, wonder what happened. But yes, when you sold parcel 5 to parcel 4, did you say I need those lots to be combined per the planning commission? Did you explain to them?
Exactly.
I did explain to him a lot of the situation with that lot. But my eagerness was to make sure that ownership of that lot would go to him. Because if you saw, I was not paying the taxes on it, nor was I maintaining it. That would have been best for the city. That parcel right there would have been up in a tax sale in the next 6 months. So I can assure the city that it's in good hands now. And I will try to talk to the new owner in combining it. Though I still think it's not advisable for the city. I really think that the city is requesting this based on the fact that if it's combined, it's going to be maintained. I believe it'll be maintained all the same, whether it's combined or not.
I
Just
believe I believe our attorney has a different, perception on that. I think he is, and he would like to see the parcels combined. Is that correct, Mr. Andrews?
I just think
You've gone again, Clark.
there's greater incentive to keep it. I mean, certainly this in order to force them to maintain it, but that's additional expense and aggravation that the city has put to for no good reason. If that property is combined, that gentleman is not gonna risk the loss of his house, but as a result of a property maintenance issue.
So it's in the best interest of the city to have those two parcels combined. Am I understanding you correctly?
That is my opinion.
Thank you.
Mr. Andrews, can I ask you this question then? For all other residents in the city of Fraser who have a adjoining parcel that is vacant, should we go to them in advising or forcing them to combine it with their primary residence to assure maintenance of that property?
My answer to that is each situation stands on its own, and those other people that have adjoining parcels did not have a site plan approval that said that they were going to develop all of the lots. You did have a site plan approval that committed you to doing that, and that's the difference. Is that if somebody owns two parcels that are next to each other and they didn't enter into any site plan approval or development agreement or anything like that, then those two parcels would stand independently. But in this instance, these parcels were there. You got approvals to develop that subdivision or development with the understanding that those things were gonna be done. And in fact, you did what you said you were gonna do with respect to 9 out of the 10 of them. But with respect to the 10th one, you haven't done it. And you have asked to be relieved of that obligation. And the city, I think, is inclined to allow you to be relieved of that obligation, provided that property was sold to an adjacent property owner and those two parcels are combined. I don't think it's our legal recommendation that the planning commission amend the site plan and allow that if those two parcels are not combined.
Well, I think I have no option other than to get in contact with our new owner on Anita, who happens, from my first impression, to be a great resident, very helpful from what I see. And I don't think that he will go against it, though I will advise him to seek legal advice from his own attorney prior to making any decision. But I will do my best to request him to combine it.
That's good. Then the planning commission should, how much time do you think it's gonna take for you to enter into those conversations and get him to submit a combination and get that approved? Couple of months?
I will talk to him first thing next week. And how long does it take for a lot combination to be approved from the city?
Within
Well,
45 days of a complete application.
Right, exactly.
Okay, so if with a little leeway, if you can give me 3 months.
Sounds reasonable.
Kenny's got his hand up.
Commissioner Perry.
Yeah, I just have a question. If Mr. Mancini sold the lot 5 or parcel 5 to parcel owner number 4, wouldn't that alleviate his responsibility altogether and it become the new parcel 4 owner's responsibility to merge? I guess I'm not understanding why we're on Mr. Mancini's behind, let's say, if he doesn't own it anymore.
The answer to that is that his obligation doesn't arise from that ownership, but arises from his site.
You're out, Clark.
Approval that he agreed to do certain things, and he can't get rid of that responsibility just by transferring the property to somebody else, unless the new owner. I would sincerely doubt that the new owner is going to agree to enter into an agreement with the city that says if that I am going to extend Anita Drive and I am going to put in water and sewer utilities so that I will have a buildable lot. If he wants it to enter into a development agreement with the city that says that he will do that, then that's a different story. Then the city has a responsible party on the hook to do it. But just by Mr. Mancini transferring the property without having anybody else assume that responsibility, we don't have any commitment from anybody that the road is going to be extended or that the utilities will be put in.
I understand. Oh, I don't want to interrupt anybody.
Go ahead, Ms. Perry.
No, I understand, Clark, what you're saying, the site plan that he was approved, but I'm thinking if whoever owns parcel number 4 did buy parcel 5, you would think the responsibility of managing that property now falls into his hands, and it kind of solves everybody's problems I would think, if he just takes responsibility of that parcel. I understand what you're saying about lengthening the street, but can't we cancel? I don't want to use the word cancel, but can't we kind of close that issue because parcel 4 owns parcel 5?
That's a decision that the planning commission needs to make as to whether or not it is willing to do that without having any input yet from the new owner. I mean, I have not talked to the new owner, have no idea what his intentions are with respect to that property. I would think that somebody that buys open land next to their own house would either be buying it for one of two reasons, either to make their own lot bigger and presumably in doing that, they would probably landscape it and make it part of, so that it just looked like they had a bigger yard.
Uh-huh.
Or the other option would be if somebody was buying it with the thought that they were going to develop it into a buildable lot. But what I am somewhat concerned about is that I believe that Mr. Mancini wanted to eliminate his responsibility with respect to this, and I can understand that. But I have no idea how extensive the disclosures were, whether the person that bought it knew that if that was going to be a developable lot, that he was going to have to extend the street and put in utilities, or whether it was offered to him for a very reasonable price and set with just an overall comment, you're going to have to comply with the city ordinances with respect to development. If he did that, he might not know that he would have to extend the street and extend the public utilities to that site. He might think that new buyer might think all I need to do is go. That's not the case. The situation is nobody is going to get a building permit for that last lot unless they satisfy the city's requirements as far as having it have frontage on a public street and have it be accessible to public
Lost you,
utilities at
Clint.
this point. And what I'm trying to make sure is that what?
We're losing you again. We lost about the last 10 seconds.
I want to make sure that that property is either developed or that it's maintained and with a minimal amount of problem to the city.
Mr. Andrews, if I may answer your question and your thought, when I did speak to the new owner of Parcel 4, Mr. Stephen Moreno is his name.
Right.
To give you an idea of Parcel 4, it sits, if you can look, it sits quite considerably back. So, and in the back, there is a above ground pool. So he doesn't have much of a lot for his child. And I told him that Parcel 5, as it stands, is not buildable unless the road is developed and sewer and water are installed. But he was not interested in that. He was interested in the fact that he was going to be able to have a nice playground because he doesn't have much land in the back because there's a above ground pool. So I'm sure his intention is to maintain that and make it part of his home so he has a good playground for his child to play in, since the backyard, as minimal as it is mostly covered by the above ground pool.
I think that's great because that way it's more likely that he's going to agree to combine it. And I would think, I'm not certainly speaking for the assessor, but it would seem to me that if that raw land is appended to his property, that it has a lower assessed value to it than perhaps if it's a potentially buildable lot. So it may even be in his interest to combine them because he may get a lower tax assessment with it.
Commissioner Farina.
It's my opinion that when Mr. Mancini was granted the site plan approval, if it was done in today, we would require him to do all of the improvements to the area before we started to build. I live in Fraser Meadows North, and when that was done, all of the improvements, all of the roads had to be extended, all of the turnarounds had to be put in at that time. I think the city extended him a favor because he was a smaller builder at the time, and he may not have had the cash to do all of that. But now I see him coming back saying, well, I don't want to spend money. I agree with what Clark says and what Mr. Herbal says, and that it's not in the city's best interest, and that's the way I believe I will vote.
Yes, Mr. Farina, you live on Rambler Drive, which was your builder completely took a raw piece of land and platted it, subdivided it, and took the responsibility of developing the roads that he platted. It was a little different on this one here. I purchased property that was already platted, and the road was already the city of Fraser's road. And I did improvements on that road individually as needed prior to getting a building permit for the house. It's a little different than Fraser Meadows.
It is somewhat different. I agree with that, but there are also some similarities. And one of those is that when somebody gets a site plan approval, to do something, they are making a commitment that they are going to complete the improvements that are a part of that site plan. And
Right.
I think the site plan that you got was not you did not come in with an individual site plan for each building lot. You came in and got an approval for whatever the number of lots were that you were intending to build on. And that included that last lot. And if you had chosen to say, well, I'm only going to do this on a 1-by-1 basis, then I think your argument would be a better one. But given the fact that you got approval for all of those lots, so that all you had to do is get a building permit and make the improvements as each one of them was going to be built, and the city allowed you to do that. Apparently that phased construction. I think that you can't avoid your commitment to do all of them, but just by saying, I've come to the end and I don't want to complete the improvements that are left because they're too expensive. I've made what I wanted to make out of this project, and I'm ready to move on. And I think that's different. I mean, somebody cannot get a site plan approval based on a commitment to make certain improvements, and then when they get near the end of it, say, I don't want to make the rest of it. Let's suppose, for the sake of discussion, that the planning commission approved a site plan with for a business, and they had a very nice landscape plan, and let's just say, for the sake of discussion, that they had a fountain in a detention pond, and the planning, and they said, we're going to make all those commitments in improvements, and the planning commission says, that looks very good, we're going to approve it. And then when it comes to actually build the thing, they say, the cost of putting in that fountain is more expensive than what we want. And I don't want to put in the landscaping. I'm ready to put the building in, but I don't want to put in the fancy landscaping. Well, that requires an amendment of the site plan, and it's within the discretion of the planning commission to decide whether or not they're going to allow that amendment to take place. Otherwise, the person that submitted it originally and saying they were going to do it has an obligation to complete it.
I see your point of view, Mr. Andrews, and I think this could be drawn out to a very legal debated issue, and who knows what the outcome is. But you know, I'm always here to. I grew up in Fraser. I've been here since I was 6 years old. I spent all my life here. So, and I try to do the best I can, and I will try to do to appease the Planning Commission's request to speak to Mr. Moreno and show him the advantages of combining it, and hopefully he will see it also the same and combine the lot. And I plan on coming back to the meeting in 3 months with that combination fulfilled. I will help him.
That effort.
I will help him free of charge and use all my real estate expertise to make it happen. And I will present this board with the final outcome in 3 months.
I think we have the makings of a motion if anybody wants to make a motion.
Move to table the
I think you should postpone it for 90 days.
I was gonna give him, are you sure 90 is enough?
Well, whatever you want to, I'm just saying, I think it's better to postpone it to a date certain than it is to table it and have it be indefinite.
Okay. I move to postpone site plan amendment 01-19 sub Max Mancini Garfield sub parcels 1 through 10 site plan amendment for a period of until our December meeting.
I will second that, as long as if it does get done sooner, he comes sooner, so we get it out of the way and cleared off the books.
Absolutely.
So we can leave it open to, if you achieve it, let's get it done and closed out if it ends up being 2 meetings from now.
Yeah, I just don't want him to break his neck, you know, doing that.
And for clarification, the December meeting is December 1.
So to give it a date certain, let's do that. Yeah, I'll second that with that. If Frank, if you'll amend it to be December 1st, and if done sooner, come to an earlier meeting.
I do that. I amended to say that.
Okay, and I support it. Okay, so roll call.
Commissioner Barr,
Yeah, I will agree. I think this is a good compromise.
thank you. Commissioner Zarnecki,
Yes.
Commissioner Farina,
Yes.
Commissioner Perry,
Yes.
Chair Warnick.
Yes. Okay, that motion carries then. Thank you, Mr. Mancini.
Thank you.
And
We'll let you
we'll
know
see
if I can get it done before December 1st. Otherwise, we will see each other December 1st.
Thank you.
Thank you.
Mr. Chairman, I think that if he actually is able to accomplish that, and the assessing office notifies Mr. O'Beal that they've been combined, that Paul O'Beal can just put it on as an item of old business on whatever the next agenda is after that, and the planning commission can perfunctorily approve the amendment on the basis that the conditions that you set forth have been satisfied.
I agree, Mr. Andrews. Is that okay, Paul?
Yeah, that's fine. And just to be clear, then that's when the lot split is complete, not when it's initiated, correct?
Correct.
Yep. Okay, and do we even need Mr. Mancini here if that ends up being sooner?
No. No, we do not.
Mr. Mancini, did you hear that? Oh, he's muted, so.
I can follow up.
Yeah. Okay, that sounds good. Let's continue. Administration report, follow up on site plan administration, post-planning commission approval.
Right. So at the last meeting, there was a request, one, for an update on the status of the Taco Bell fulfilling its site plan approval conditions, and two, just some context about mechanisms that the planning commission has in place to ensure that applicants follow through with the commissions that are required of them as part of site plan approval. So I'll start by saying that the Taco Bell property, the developers of the Taco Bell have submitted to me a drawing that I believe will solve the issue and fulfill their condition. I've approved that drawing and asked them to proceed. They submitted that drawing in June. I asked when they would be implementing it. They initially told me fall planting season, and then more recently said it might be sooner because they could, the landscaper had an opening. As of Monday, the additional planting has not been completed, but I am in contact with them and will continue to report until it is resolved. As far as the mechanisms, Mr. Andrews had compiled, and I put into the memo that we provided, the parts of the zoning ordinance. The Planning Commission has a fair amount of ability to sort of impose extra conditions, or I'm sorry, to use mechanisms to ensure that conditions are fulfilled. One of which is the performance bond. I think there was a question about that at the last meeting, but it is existent in the Fraser zoning ordinance that when the Planning Commission finds it appropriate, that they can require cash deposits or letters of credit acceptable to the city, covering the estimated cost of improvements. And so that is on the books. That I think that was just a matter of some question. I think in general, there was also a question about what process the administration follows to ensure that these conditions are fulfilled and that these things happen. And so I tried to illustrate that to just sort of pledge that this is how things should happen and will happen going forward. There's two real checks, I think, that are incumbent on the entire administration, but especially on the planner. As soon as the approval happens, the planner and other departments, including the attorney, work on facilitating those conditions with the applicant, or make them aware, remind them in writing of those conditions. But the big, I guess the first gate, the real first check on that is the permit drawings. So when the permit drawings come in, the planner, I will have a review, at which point I will check to ensure that those conditions are in progress and that the any physical conditions are reflected in the site plan. So that's the first sort of gate, or the first point at which the administration can make sure that's being followed through on. And then the permits are issued, and we will do a final review and a final site walk as part of final inspections to make sure that the zoning ordinance is still complied with and nothing has gotten revised in the drawings without the city's knowledge. So I'm happy to answer any questions about that process. And I think I will come to you next month with, I'm in the process of just sort of ensuring that with all the transition that's happened at City Hall, that there are not dormant ones. There really haven't, of the site plan approvals that have happened since I've been here. The Hockeyland Arena one, as you know, has come back several times, and so is not. They've initiated some permit reviews, but there's a lot of work to do on that one. But I will come to the next meeting or distribute as part of your next packet just sort of a status of the ones that are still outstanding, so you're always aware of that. And Mr. Andrews, I don't know if you have anything to add. I just sort of spoke for you as far as the mechanisms.
I just wanted to make sure that the plan, when we talked about it last meeting, I said, if we need to amend the ordinance, we can amend it. But I thought before doing that, I would see what was already on the books, because I thought there might be some provisions, and there are in fact some provisions. And I think that those are probably adequate to be able to take care of the concerns that the Planning Commission has, as long as everybody's on the same page and is actually operate in real life, and it's great that, or there's no procedures in place to make sure they're followed. That's a different story, but I think Paul is on top of that process and is in the process of implementing procedures to make sure that things don't slip through the cracks.
I can add, what I always did as building official, I did all the plan reviews. And if you look back in all permits that went through an approval process of planning or zoning, I always put on my stipulation sheet, I said
In a meeting.
that stipulations of, then I'd give the number, must be adhered to before final approval of this permit. So that covered it, at least in the permit process. So, and they had to sign that. So that was a standard thing. So I wouldn't final something unless it got done. So that's part of the building process there. So that can be a safeguard. And then whatever you do as a planner, I think with a combination of all of them, and Bruce can look up and see all the old permits and how I did it. And it's pretty efficient, and it covers that part of it. At least they don't get finaled unless they met all the stipulations, stipulations of that approval process. Commissioner Farina.
I think I'm the one that's kind of trying to push this forward because there's been two or three that have come to our attention. One was Grossbeck and 13 Mile Road, the dumpster locations. They put in dumpsters and they were issued an occupancy permit and nobody seemed to know about it. There was the one I called Paul about, Taco Bell. And I think there needs to be a process, a check sheet, something in place that ensures that at the final approval, that's happening.
Mm-hmm.
To just say we're giving them occupancy permits, pending, and then never going back and checking to the final, the site plans, unless the commissioner goes out and finds it, it's not a good idea.
Right.
And that's
why that process works good, and they sign it, and they're right there saying, and a lot of them, I'd go back with stuff and they'd say, "Oh, I don't remember signing that." Said it's here. There's the copy of it right there. You sign. That happens in all building permits. They don't even read the stipulation sheets. They just sign it. And I would have a long, drawn out process. And Bruce can probably find my stuff on the computer. And it's
I'm telling you that if I've gone out and found two, there's more that slipped through that nobody looked at. And that's why I'm trying to get a process in place to go and do that.
And I think a checks and balances works, having a few different things.
Yep, exactly.
So I'll take that for what we put into it then, Paul, and maybe between everybody, we can have a process then for the next meeting.
Sure.
Okay. Are we good with that? Anybody, any other comments? All right,
Good job.
so.
Yeah, thank you for sharing that all with us.
Yep.
You're welcome.
Public communications and non-agenda items, nothing there. Zoning Board of Appeals member liaison report. Have we had any meetings?
No, we haven't. We're scheduled to have one next month, I understand, from Paul.
We can put you to use again on that number 9. Commissioner comments and items of interest. Start with Commissioner Barr.
I have no comments at this time. Thank you.
Okay. Who's next? Frank?
Have we got names for the vacancy that we have? And who would they turn them into since we don't have a city clerk?
I've spoken to the city manager about the vacancy. It is on her list, which is, as I understand, pretty long. But she's aware that it's happening, and so I think that they'll be turned into the city manager, or her assistant, who is not exactly the acting clerk, but was assisting in some of those matters. I think the resources that are in City Hall right now, as far as the clerk goes, we're getting ready for the August primary election and making sure that candidates are certified. So I don't have a report as far as names, but I guess just that the process has been initiated.
Yeah, I talked to the city manager, and she's I got her hooked up with some of the retired guys with the sign, because the sign wasn't active out front, and I wanted to get that up on there so that people going by would see it. And city manager Elaine was following up on that. She's gonna try and get that going too, so she knows what we need. So hopefully with everybody pulling together, maybe we'll get something going on that. So any other things that we can get out, whether it be online or anything, to get that we're taking applications?
It was my understanding that the administration in the past has provided the planning commission with applicants to interview, and then
Yep.
you
Yes.
select them, interview them, then okay.
Prioritize them.
Yeah.
Yeah.
So if you can just keep us up to date on applicants that come in,
For sure.
and we'll do them as they come in.
Mm-hmm.
Just add them to a meeting if we can. If you can put it on your agenda, so we know ahead of time that we're going to be interviewing.
Yes.
Okay. And we had regular questions that we did, but whatever process you come up with, Paul, we'll work with it.
Sure. I think I did find some history as far as the interviews and things. I just wanted to, I hadn't yet put my hands on like the full documentation of how that had happened in the past.
Yeah, I can always get with you too if you need help on it.
Great. Thank you.
Okay.
It's about
Frank, that was it.
August 22nd, St. Malachy is going to have a one-day festival. So if anybody's interested, there's going to be food trucks there for food, and of course adult libations, and a band, and bingo, I think. So,
and I'll be selling 50-50 tickets with my daughter.
There you go.
So there's some good pots come out of that. We have I missed Commissioner Zarnecki. You're next.
Maybe two things. One, I don't know if there's an update on the master plan and where we're at with that. And
well, that was mine too. Yeah.
And also with Mr. Cook, he did have the capacity of vice president, vice chair. So I don't know if that should be filled, or we wait until we get another person on the board. Those are my only two comments.
Okay. And yeah, we got that letter from Roseville too on their master plan. Did everybody get that? I don't know. In your packet, did you get everybody get it?
I don't recall seeing anything.
No.
Oh, was I the only one that got that, Paul?
You're the chair.
You might have been. I actually was not aware of that, unless a while ago Roseville had solicited comment on their master plan, so we talked about it.
Yeah, so they had the public hearing already, so they're in the final stages too.
Okay. I think you might have gotten that. I didn't get that.
Oh, they threw it in my packet. Probably was.
Yeah, it might have just come mailed directly to you. Yeah.
Okay.
Can you send it out to us?
Yeah, I'll make copies, send it out. I'll scan it and just email it to you if that's good.
That's good with me.
Okay. Is that it, Kath?
No, I following up on what Kathy said, have we received anything back from our outlying cities that we send our master plan out to?
No, and actually it was in my comments. What I was going to announce is that in the, that comment period had expired, and you recommended it to City Council, and since you have met last, City Council adopted it as well. So it is in force. We are, Secretary Perry, I need to coordinate with you to get a signature on a resolution so that we can publish it, and I'm working on getting the council signature as well. But what's left to do with that is to publish it to all the SEMCOG and all the relevant agencies. But essentially it's done, and we just need to get it on the website and start implementing it.
Congratulations.
To all of you, more than to me.
It's good. We're on the move.
Yes.
All right, Commissioner Perry.
Nothing at this time.
And Clark?
I just want to express my condolences to the Cook family on the passing of Mr. Cook. That I'm stunned by that, but other than that, I don't have anything further.
Okay, Paul?
I have nothing additional, no.
I don't know who's out there still. Is Dylan out there and Alyssa?
Yep.
Anybody have anything? Dylan?
Nothing for me other than, just to reiterate kind of the best wishes to the Cook family.
Okay. Do we keep you up late tonight?
It's getting close to my bedtime, but I'll hang out for you guys.
Clark will understand tomorrow. Clark will talk to the bosses. Alyssa, was there anything?
I would just echo the sentiments from both Mr. Church and Mr. Andrews. I know everyone on the board knew Mr. Cook way more than I did, but in the 2 years that I've been around, he was always a positive person on the board for sure. So I know he'll be missed by many of you. So.
Yep, and that's my comments then too. And Don was it's going to be hard to fill his shoes. He was such a active guy with the Goodfellows, and I could rely on seeing him on the corner of 14 and Garfield with his newspaper. I was playing golf together, and he's one of those guys. He was just an all around great guy, and we're going to miss him. So we got to move on. Let's try to get somebody that we can replace him with, at least. That's,
Are we going to wait to replace him before we hold elections? Or are we going to do it prior to that?
Let me look at the bylaws about vacancies, and I'll check on that between now and the next meeting.
Good.
Thanks, Clark. Do we have something for the next meeting already, Paul? Or
we have a couple tire kickers, but nothing that is actually in process.
Okay,
So
well,
I think there might be something, or I guess pending the speed of the application process. As of right now, there are no business items for next meeting.
all right, keep us up to date. Anybody want to make a motion to adjourn?
I move to adjourn.
Do I have
Support.
support? All right. Do we need roll call? No, we don't. That's what we decided last time. So, right? Didn't we say that?
I believe that's true, yes.
Yeah. Or you can just say yes or no.
Yeah.
I'm yes.
Yes.
Yeah.
Yes. Good night, everybody. We'll
Good
see you
night.
the next meeting.
All right,
Good
bye-bye.
job,
Good night.
Randy.
Right on.
Good night.
Good night, Mark.